So thank you for the opportunity to talk to you today. Firstly, because I'm back with my Friends in Reconciliation Queensland, an organisation which, as Peter said, has my husband's and my full support. I'm pleased to be able to talk to you today about two issues of great interest to me. Firstly, the Murri Courts of Queensland, of which I have a sound knowledge, and secondly, the concept of justice and whether it is delivered to Indigenous people in Queensland through these courts. The concept of justice itself is so much a larger topic, and I'm not a criminologist, just a mere lawyer and former judicial officer. I once wrote a book entitled Nothing to Do with Justice, so I hope that doesn't disqualify me from talking to you today. That book was published at the end of my judicial career, but it was in my experience as the Chief Magistrate of Queensland from 1999 to 2003, the first female Chief Magistrate, that I began to wonder, as many had at the time and before me, what could be done in relation to the concept of reconciliation between white and black Australia. Like so many other lawyers, judicial officers and academics, we were tussling with the findings of the report of the Commission into Aboriginal Deaths in Custody, which reported in 1991. We were told that Indigenous Australians were much more likely to be imprisoned for offences than other Australians. Once in prison, they were more likely to die in custody due to loss of culture and isolation. So I began to think outside the box as to how the Magistrates Court of Queensland could possibly bring about some change in these troubling findings. I had been aware for some time, and indeed explained to magistrates at a recent conference of magistrates, we're talking about the year 2000, 1999-2000, the concept of therapeutic jurisprudence. Has anyone ever heard of it? I hadn't at the time. And what it could mean to certain defendants before our courts. In a nutshell, it is a concept which had arisen out of United States courts in California, I believe, where judges were becoming exhausted and frustrated by the continual appearances of defendants before their court, whose offending was as a result of addictions to drugs or alcohol or mental health issues, for example, where the offending was directly related to their addiction. The judges began to think that if the addictions could be treated during a period of time following their first appearance in courts, there would be a double result. There would be less chance of the defendant spending time in prison, and if they had rehabilitated, say, there would be less chance of reoffending. Further, and most importantly, there was the prospect of great improvement in the lives of defendants. The concept depends on the cooperation of the defendant in relation to the prospect of rehabilitation and the time taken by the judge, who must be prepared to suspend final sentencing until the defendant is given time to make the effort to change, to build some sort of trust between the defendant and the criminal justice system, and to be patient, as rehabilitation can take some time. This is so different to the regular pathway for defendants through the course. Yes, rehabilitation is taken into account on sentencing, and defendants put on probation and community service orders, for instance, but once that sentence is handed down, the judicial officer just does not see the defendant again, hopefully not at all, maybe for some time. Now, I cannot emphasise enough to what degree this concept presents a challenge to most judges and magistrates. One of the long-held tenets of the administration of justice throughout the courts is the promise one takes at one's swearing in, that everyone who appears before you will be treated equally. This can result in judges and magistrates appearing remote and even arrogant in their attempts to appear unbiased. In busy courts like the Magistrates Court, the busiest court in Queensland, they may appear rushed and less likely to always have the time to hear the stories behind the offending. Isn't that a wonderful sight and sound? The philosophy behind this principle, which allows this type of behaviour by presiding judges, rests upon the idea that all persons come before the courts equally. Obviously, taking into account unequal opportunities in life, The differences in parenting, gender background, and yes, cultural background. Is it possible to have a typical, average or representative defendant before the court? Offenders are before the court for many reasons, because they are undereducated and ill-trained for work, they have been abused or neglected, or worse, assaulted sexually or otherwise in their childhoods. I once heard a heroin addict at a conference on the radio say that heroin was called the love drug because it took away all the pain of the past. They are addicted to substance, they are desperate, they've been racially discriminated against, and in the case of Indigenous Australians, still suffering from the trauma of the invasion of Australia. But to ask a judge or magistrate to take the time and effort to really look into the background of a defendant is quite challenging, even threatening. Some even say, I'm not a social worker, I'm a judge. Others say, efficient and quick justice is good justice. However, already in my days as Chief Magistrate, the Queensland Drug Court had been set up with the principles of therapeutic jurisprudence in mind, and it was part of my job to help support the Drug Court Magistrate in dealing with the setting up of the court and the government departments and programs being provided and all of that. But there was legislation which introduced the courts, and it set out the roles and duties of the magistrates who were to sit in the court. The court was funded to provide sufficient support to the magistrates, as well as funding for programs aimed at the rehabilitation of the defendants. How well they went on the road to rehabilitation, or indeed if they were able to beat their addictions, depended on the support given to them. But primarily, if they had reached that point in their addiction or lives where they hadn't had enough and wanted to regain some normalcy and indeed hope in their lives. As they say, you can't help someone who doesn't want to be helped. So drug court magistrates could expect to be involved in the lives of defendants for up to 18 months as they attempted rehabilitation, sometimes failing, sometimes reoffending. They were punished with time in jail sometimes for the breach of orders of the court, so it wasn't an easy road. Sometimes they fell off the wagon, but they got another chance if they seemed sincere. Again, sitting in this sort of magistrate court is not for every magistrate, and again I know of the drug court magistrate who first sat in the court, that he went to a number of funerals of participants. So not an easy road at all. So while this concept was taking hold in my mind, approximately 1 year into the job as Chief Magistrate, in the middle of 2000, I was informed that the then Chief Magistrate of Victoria, in the spirit of reconciliation, had recently held a series of apologies ceremonies to Indigenous peoples in Victoria. I thought this sounded like a good idea. I didn't know it, but that magistrate lost his job over partly those ceremonies and other matters. Maybe I shouldn't have listened to him. But I was proud of him for doing it. So I had set out with a goal, quite honestly with the magistrates, to make the Magistrates Court of Queensland more relevant and accountable to all Queenslanders which it served, and I saw the attraction to Indigenous people of such an apology coming from the magistrates' courts around Queensland, where after all, most of the justice handed out to Queenslanders come from. I used to be able to quote the statistics about how much work is done in the magistrates' court, but I know it's way out of proportion to the higher courts because we're the court of first call as a start. I consulted with the magistrates on the Indigenous Issues Committee of the Queensland Magistracy, about 6 of us and 2 Indigenous magistrates then appointed, and we decided to go ahead with ceremonies throughout Queensland at approximately the same time on the same day. What I did is called leading from the front. I knew I had the right to speak on behalf of all magistrates under the Magistrates Act, and I took the opportunity to do so. I had the support of my Deputy Chief Magistrate Brian Hine to go ahead with the ceremonies, and he was indeed present. He explained to me where his motivation came from, when at another time in his life he had been a clerk of a court in the administrator of the court in rural Queensland. At that time, Aboriginal people received their pay for the week from the clerk of the court, the same person who had to agree to the purchase of various items like shoes for the children. He had never really got over this. The clerks of the court also extraordinarily had the power to name Aboriginal children. Perhaps that may explain why there's such a sprinkling of Irish Catholic names among Aboriginal families. I don't know. I think Brian wanted in some way to make up for those breaches of human rights which were not of his creating, but which he was bound to follow. So on 9 August 2000, a ceremony was held in Court 1 at Roma Street with many people present, including journalists, as the event had become touched with notoriety, especially when the Chief Justice of the Supreme Court had come out publicly against the holding of the ceremonies, as he said that is not the role of the courts. The then Attorney General Matt Foley, however, supported the ceremonies and was present. A Supreme Court Justice, Rosalind Atkinson, attended, which cheered me greatly. The feeling in the court was dramatic and tangible, and I thought to myself, will I end up on the branch of a tree which was about to crack, or would the good feeling behind the gesture be appreciated? That is why the Deed of Apology and Commitment said, which I read out to you now, the magistrates of Queensland apologise and express their sincere sorrow and regret for the injustices of the past suffered by the Aboriginal and Torres Strait Islanders people of Australia, and particularly the Yatsi people of Queensland. We commit ourselves to the Australian Declaration toward Reconciliation. We promise to embrace to the best of our ability the cultural and spiritual values and sensitivities of all Aboriginal and Torres Strait Islander people to ensure that they, together with every other person interacting with the courts of Queensland, will receive equal justice according to law. The ceremony went very well, and I was most touched by the words of 2 elders, one Aboriginal and one Torres Strait Islander, who spoke most elegantly of their pleasure at the ceremony. Steve Mann, that's okay, quoted from Aboriginal poet Uluru Nunakal, "From the father's father, the pain, the sorrow, for our children's children, a glad tomorrow." My tomorrow, however, was not so glad, as I had immediately to deal with the angst of some magistrates who thought I had gone too far and took the statement about past injustices as personal. It's called literal interpretation. You read an act regardless of, or lines in an act regardless of the context. And they were very cranky. I hadn't put to them. Quite frankly, I'd have never probably got agreement. So I'm a naughty girl, really. I attempted to explain that I was not saying that Indigenous people were treated in a racist manner before the courts over a long period of time, but more that their culture had not been appreciated by many institutions, of which the Queensland Magistracy was but one. However, one magistrate at least said he was so angry with me that he could not sleep at night and could not forgive me for my actions. On the other hand, the lovely letter I received from the Aboriginal and Torres Strait Islander Legal Service in Brisbane raised my spirits, as it expressed the joy and comfort of such a message from the courts and what it had meant to Yatsi people throughout Queensland. I showed that magistrate that letter, and I never heard from him again. He seemed to get it, perhaps. I somehow weathered that storm and soon realised that the apology ceremony had been important in another and most important way, and not merely symbolic. Again, relying on the experiences of other magistrates in other states, I discussed again with Brian and others the possibility of structuring a specialist court where Indigenous Queenslanders appearing before our courts could receive justice based on an understanding of their cultures and beliefs. We had a guideline which resided in the Penalties and Sentences Act Queensland, which states in a section devoted to governing principles in relation to sentencing, issues to which judges and magistrates must have regard when sentencing a defendant. It says, if the offender is an Aboriginal or Torres Strait Islander person, any submissions made by a representative of the community justice group and the offender's community or other respective person that are relevant to sentencing the offender, including, for example, the offender's relationship to his or her community, any cultural considerations or any considerations relating to programs and services established for offenders in which the community justice group participates. Were we not just taking the interpretation of this section to its ultimate conclusion? If Indigenous people in Queensland could see that by being truly listened to by magistrates in relation to their pasts and their offending, and to have the appearance of elders sitting with the magistrates in a more welcoming place, could this give the hope and trust needed to address their offending and plan for a better future? We knew that we needed to make the court less authoritative in design and practice, yet still uphold the respect for the magistrate and indeed the elders. We began by speaking to local elders to establish whether there was support for the idea. We were able to explain to them the model from other Indigenous courts already set up in South Australia, the first to have such a court, the Nunga Court, the Murri Courts in Victoria, the Circle Courts in New South Wales. Some were set up for other reasons, not so aspirational as actually engaging with the defendant to set him or her upon a better path that did not include a prison sentence. Their idea was more that the defendant would feel more comfortable in the courts and begin to trust the court system and turn up to court when on bail, which is very important. It's a criminal offence itself. We hoped for the full package, and the elders, again, whose respect we had garnered through the apology ceremony, were now our friends. So it came about that we held that ceremony in August 2002 to launch the Murri Court of Brisbane. Again, the ceremony was moving and had the support of some, but not all, Queensland magistrates. It's a lonely place at the top sometimes. I had asked Brian to work with local elders who were prepared to sit on the court with the magistrate, and that I would handle relations with the government and other courts if necessary, and handle the media, one example of which I will mention below. It's all right. Is there a seat? Seat up the front. We were making this step without, like the drug courts, any legislation to base the procedures on, and absolutely no funding for elders to sit in the courts on a regular basis or for programs to assist defendants with rehab. How did we hope to bring such a court into being as an established facet of the Queensland criminal justice system? Not surprisingly, some magistrates were keen to participate in the courts throughout Queensland in due course, some were not. I began to have the feeling, though, that just because a magistrate wanted to sit in a Murri Court, was he or she the best magistrate to do so? I believe that every magistrate who put his or her hand up needed to undergo cultural awareness training, but that did not happen on my watch. So it was rather, came to a stop. At the end of that day of the launch, I was interviewed in my office by a reporter from the ABC, if my memory serves me correctly. Although we had been chatting in a friendly way, as soon as the cameras started rolling, she went for the jugular. She said to me, "So, Miss Fingleton, are you telling us that with this new court, you will be treating Indigenous people differently to others?" Now, I had worked for a couple of politicians in my previous life and had had some experience with the media myself at that point, and I thought to myself, "Honey, you are not going to spoil my hard work and that of others in getting this court together, and you're not going to spoil my day." And I said to her, looking her straight in the eye, "Oh yes, absolutely." Good answer, eh? And given the desired hesitation on her part, went on to explain exactly why the court had been set up, to treat Indigenous people in a particular way, to recognise the past and the scars from that, shall we say. So what is the structure and what are the procedures of the Murri Court? If anyone would like to, you would be most impressed if you want to visit the Brisbane Murri Court, which sits each Wednesday in a specially designed and most attractive court, number 25 of the Magistrates Court building, at the corner of George and Turbot Streets. You will see Ms Tina Prebatura, the Brisbane Murri Court Magistrate, handle a busy schedule of defendants. Those defendants will be appearing possibly for the first time before the court on referral from a call-over of criminal matters at a previous normal court sitting. Other defendants may be appearing for perhaps the fifth or sixth time. And you'll also see physically that the court is most attractive. It was specifically built for the Murri Court. It is used for other things, but it has a large, not exactly oval table, but differently shaped with a beautiful Aboriginal artefact on the top of the table and beautiful paintings and other Aboriginal and Torres Strait Islander art, some done by prisoners, and it's just different and beautiful. Originally, defendants were referred to the Murri Court if they were at risk of imprisonment through their offending. This, which, as I explained, was a matter of great concern, to me anyway. This changed over time so that now the criteria is that any defendant, whether likely to be sentenced to a term of imprisonment or not, is eligible for the Murri Court. Since 2012, every defendant must be on bail. Defendants refused bail must go back to the mainstream. No charges of violence, sexual assaults or domestic violence breaches are allowed in the court. This has quite a bit to do with the elders' safety and the problems they might have within their own communities. The defendants will have undergone a meeting with the officer from the Department of Justice who writes up a cultural report for the magistrate, and if time, the elders assisting the magistrate on that day will have met with the defendant. The role of the elders in the court is vital. There are usually two elders present, one on each side of the magistrate. They are usually gentle with the defendant, but strict when it is appropriate. I would not like to be on the receiving end of some of the conversations I've observed as magistrate. Shaming is part of their approach when appropriate. One can see that the defendant is relating to the elders, no matter how good and modest may be the judicial officer. He or she is no replacement for an elder with an understanding of a shared culture. Although they discuss possible programs and eventual sentences with the magistrate, it is still a court of law though, and only the magistrate can carry out sentencing, for instance, and order programs. The defendants will have to agree to further consultation with the elders and the cultural officer and to take part in programs or a program to assist with their particular issue, be it drugs or... excuse me. Oui. Throw it all over myself, I don't know. So they have to agree to a program, be the problem drugs or alcohol or lack of understanding of the effects of their offending. And you know, cognitive theory is a big part of rehab, that you actually realise what is right and what is wrong if you've forgotten. If eventually on sentence they are put on a community service order or probation order, they will be subject to regular reporting to officers of the Department of Corrective Services, and that officer will report back to the court. Where appropriate, especially in rural areas, the rehabilitation may involve a return to country. So not an easy commitment, but a chance to turn lives around, all within their own cultural context. They return to court on a regular basis, as I said. The idea of these courts, which I didn't perhaps emphasise, was that unlike a normal court which sentences, and then it may be, there may be rehabilitation or a program recommended, and then if you breach that, you can end up back in court for the breach, as well as you haven't been encouraged enough to continue. So the sentence in these particular courts are adjourned until the person's had been given a chance at rehabilitation. So the behaviour, the improvement while on a program is taken into account, in other words. The courts began to be held in other parts of Queensland, Rockhampton, Mount Isa, Cairns and others. Funding did kick in eventually, I'm pleased to say. Limited funding was provided up until 2012, until the Newman government defunded the court. It was refunded and relaunched in 2016 by the current Attorney General. The courts had never stopped operating though, thanks to the energies of the magistrates involved and the generosity of the elders, still working without any reimbursement for their time spent, not even travel money and not even lunch money. In fact, my friend Tina Prevatira fed her elders lunch for several years, particularly liked her egg and thyme sandwiches. However, now there are, and it's a good reason to keep living a long time, now there are 14 Murri Courts in Queensland, and the government recently provided $300,000 for payments to elders over a 3-year period. This means that an elder gets a sitting fee of $100 for each court date. When you think what lawyers earn, my heavens, but anyway. But there is no funding for their involvement in cultural report interviews, board meetings, training or yarning circles, which are sometimes used. However, they are now provided with lunch, as is the defendant, which is a nice touch. In 2017-18, 615 defendants, 588 adults and 27 children appeared before Murri Courts in Queensland, according to the annual report of the Magistrate Court of Queensland for 2017-18. I myself have sat in a Murri Court as magistrate at Caloundra from the years about 2007 to 2010 when I retired. We set out to develop what grew into a well-functioning court, not well-funded, but well-supported by local agencies and indeed by the clerk of the court and other members of the court at Caloundra. I've recently been informed that it continues to operate. It was a learning experience for us all and the foundation for great friendships between myself and the local elders. It is also important in any specialist courts, drug courts or Murri Courts, to have a prosecutor who understands the principle of the court, to, if possible, resist the thrusts of so many prosecutors in many courts to argue for imprisonment for the defendant. That's a fact of life. Instead, he or she has the opportunity to see the defendant undergo culturally appropriate programs which may improve the defendant's life and keep them from further offending and possibly jail time. This I had at Caloundra in Sergeant Steve, who got the vibe of the court and always behaved impeccably towards the defendants, the elders and the magistrate. Now, to deal with a couple of elephants in the room in this discussion of justice for Indigenous people through the Murri Courts, as a friend, a Professor of Law, Eleanor Marchetti, recently said, when you receive government funding for a program, that program will require constant evaluation. Eleanor has herself been part of that process. Government will want to know if the money they have provided has been well spent and what positive outcomes have come out of that spending. Originally, the test thought to be of most importance in reporting on the success or otherwise of the Indigenous courts was of the rate of reoffending of defendants appearing before the Murri Court. You might think that's common sense. The answers provided to government, however, were not positive, and the rates of reoffending did not particularly show a reduction. What has been impossible to measure, except by word of mouth, when interviews were carried out by the researchers, was the attitude of the defendants toward the courts in terms of respect and willingness to appear on bail firstly and take part in programs successfully or not. This aspect had grown significantly. Is this enough of an outcome for the funders? Well, they're still funding it. I would suggest yes for 2 reasons. Firstly, any innovative program deserves a well-funded trial and the continuing provision of programs for rehabilitation. Secondly, as I suggested earlier, a court of law, even when the presiding magistrate is trying his or her best to work with the defendant elders and other members of the court team, cannot turn around years and years of discrimination, lack of opportunities and societal racism against the Indigenous people of Queensland. Yes, a national apology from a Prime Minister to the victims of the government policy resulting in the stolen generation gave some release of anger and depression toward the white Australian culture. But where is the recognition of Atsi peoples in the Constitution? And where is the treaty, so very long overdue? The last report to another Prime Minister was ignored. So what can we expect from Murri Courts in Queensland? not justice for all the egregious behaviours by white settlers and their descendants towards Indigenous people. No magistrate would sign up for that job. But we can expect that relationships between Indigenous people and the criminal justice system can and must be improved and honoured. Things have changed a lot. Now the Department of Justice has a reconciliation action plan. One of its opening statements says, "Reconciliation means to understand, respect and embrace another's culture, reflecting on one's own actions and then taking lead to implement change. This process is the key to building a stronger, dependable and united nation. The plan outlines many ways in which this reconciliation could be advanced, including through the Murri Courts. The story is also told in that report, in another document I read, written by Annette Hennessy, another magistrate friend, while working in the Rockhampton Murri Court. The elder said to her one day, "We elders have been waiting for 50 years to be invited into court to help our people." I can say it feels mighty good to have played a fundamental and basic part in that process. So back to nothing to do with justice. They're not bad photos, are they? Vanity, vanity.
I'm not surprised.
Oh. My book was published at the end of my career after my return to the bench and my retirement. I endeavoured to explain why it was that I could get over what happened to me so as to be able to not only move on with our lives, my husband and mine, but to return to the magistrates court bench, as I did in 2005. Despite the despair that my husband and I had suffered when I was charged and convicted of a criminal offence, something wonderful finally happened. I took the law to its limits. Great lawyer friends organised for my case to go to the High Court, and the judges there believed me. I had always said that I had merely been doing my job by sending an email, admittedly a cranky one, to another magistrate, as Chief Magistrate. And there it was, an immunity under the Magistrates Act, which said I could not be charged, convicted or imprisoned for something done in the course of my job as Chief Magistrate of Queensland. Now, a lot of people in prison will tell you they didn't do it. I knew I hadn't done anything wrong, and the prisoners and officers would consistently say, "What are you doing here?" And I'd say, "I don't know." However, another reason I fared pretty well following the destruction of my career, imprisonment, and the stress of waiting for the High Court to make a decision that would determine the rest of my life, as in getting a criminal conviction off one's shoulders, as like carrying the Story Bridge around. But I had a secret weapon. You see, I never ever felt shame while going through the entire process. I knew, as I said, I had not committed a criminal offence, no matter what any prosecutor, judge or jury said about me. And I knew I was a good person who not only respected the law, but had attempted to make sure all found justice in a court of law. So I say, if Indigenous people can hold on to their belief in a system designed to help them in particular, the setting up and continuation of the Murri Court will not have been in vain. Thank you for listening.